I want to welcome everyone. My name is Leah Wing, and I am the co-director of the National Center for Technology and Dispute Resolution, and I'm hosting today and also moderating. And if you'll bear with me, I'm just going to share my screens now and give you a chance to take a look at our fabulous panel. As I mentioned, I think that these are some of the most exciting and important and frankly urgent issues that the field is not only facing now because we're adding technology, but has really been facing our field for generations and generations. I am thinking back to the Freedmen's Bureau in Reconstruction in the US after the Civil War and the inequality in arbitration racially. And then I'm thinking back to, as I drink my teacup this morning from a spider mug, I'm thinking back to the many conversations that we had in the early new wave of the movement in the 70s and 80s with how we will address issues of inequality, culture, ethics, and equity. So these are ongoing, prevalent issues. Technology gives us a chance to face them in different ways, but they also add new challenges. So I'm incredibly excited about our panel. I'm going to ask if each person will introduce themselves, but you could see the order in which we're going to go and the topics that we're going to cover today. We are celebrating the new edition of Online Dispute Resolution Theory and Practice, Treatise on Technology and Dispute Resolution, that has recently come out. And one of our panelists, Dan Rainey, along with Ethan Catch, who's the director of the National Center and also the father of ODR, and Mohammed Abdul-Wahab are the three editors, and they've done an amazing job in pulling together this important treatise and really have put their shoulder to the wheel and done so much work. So we want to thank them and celebrate them today. I'll be putting this information in the chat as well so that you can have access to the 40% discount if you're interested in getting a copy. And this is one of the webinar series that have invited all the authors and the editors to speak to the parts of the book that they contributed to. And there's 3 more presentations this week. We hope that if you're free, that you'll take advantage of participating in those, or that you can see them once they're posted online if you're not available at these times. So without further ado, I'm going to speak to the beginning part of our chapter that I was lucky enough to co-write with Dan, and it focuses on ethical principles and standards for ODR. I think that our major argument in the chapter is really that anytime you add technology to dispute handling, dispute management, dispute resolution, it has ethical implications. Many of us have been using bits and pieces of technology long before we thought of it as ODR, whether we email clients or we do document transfer or we start to use collaborative tools for drafting agreements or for brainstorming. And now there's really, over the last 25 years, the development of a subfield in the field of justice studies and also in the field of law and in the field of dispute resolution, where we're calling it online dispute resolution. And we would argue that anytime you add technology, as I said, it raises risks. But of course, it also has a tremendous amount to offer. And I'm going to talk a little bit more about that. But the field has only begun to address, only at the beginning stages really, of addressing the ethical implications. And we certainly don't have a field-wide approach yet to this. So we give a couple examples in the chapter, and I'm going to take a part of one of them. We look at a practitioner perspective, someone who's a mediator, and we look at a negotiator's perspective. So let's just take a moment to try to ground this in what would be realistic for many practitioners. So after practicing mediation for more than 15 years, she decided to add online dispute resolution to her toolkit. So many people either shunned the idea of using technology, particularly video conferencing, or what they would consider ODR in their practice until the pandemic made it necessary. And for other folks, they just didn't have time or they hadn't been trained in how to think about incorporating it in their practice. So the pandemic brought many people to the fore in engaging with and a set of concerns clearly could be raised for any practitioner. For example, if we're using video conferencing, how can I know if somebody else is in the room with one of the parties? As a third party, do I have a responsibility to ensure that that's not the case? How can I ensure that one party doesn't record the session and then post it on social media? And even if I get them to sign an agreement that they will not do that, what if they do it anyway? What's the implications for my practice? What liability do I carry for the security of the data? So that would be from one particular practitioner's perspective, but let's zoom out and think in a broader way about some of the ethical and practical dilemmas that I think we'd argue those are intertwined. We're not just talking about morality, we're also talking about real concrete practitioner-related dilemmas or systems design dilemmas. So what kind of new training is needed for practitioners to prepare them to use technology? Do we need new components to our agreements to mediate, both for what we're promising and the limits of what we can promise, and also for any commitments we need from the parties? And are there new requirements for confidentiality when we start incorporating technology, whether it's, as I said, brainstorming tools, collaborative writing tools, case management, video conferencing, et cetera? And what kind of criteria do we need to use in order to select the best video conferencing software? And if a court is going to incorporate an ODR platform, what criteria should they be using? And I want to take a moment to think about, let's think about a divorcing couple, or let's think about a neighborhood dispute, just as an example. And if you're the mediator and one party is familiar with the video conferencing or the case management software, they're very used to engaging in using technology in their everyday life, and the other person is entirely unfamiliar or uncomfortable, inexperienced at using the software that you're asking them to use, then we are escalating an inequality in comfort level, in participation, and therefore, in a way, in empowerment. And if we're going to make sure that people feel comfortable and feel familiar with the tools, who's responsible for teaching them? So you might be a wonderful practitioner. Does that mean that you're familiar enough with the technology to be able to teach someone how to use it? What kind of coaching do we need? And if one person needs help and the other doesn't, then who's to pay for that? Are we going to charge different amounts to our clients? What kind of ethics should guide an ODR system design for labor or commercial negotiations? Should there be any ethics? That's certainly worthy to engage in the conversation and debate about. What kind of ethics do we need for designing ODR platforms, arbitration-related platforms, or ODR for courts? These are just a few of the many, many questions that the field is in the middle of discussing, but we don't have an agreed upon commitment from each other or patterns and norms yet. We would argue that ethical guidance and accountability mechanisms are really key to both developing and using tech in dispute resolution, not only to protect the core tenets of our field, like I mentioned already, a commitment to confidentiality, a commitment to empowerment in mediation, for example, to fairness, procedural fairness, but also we can use technology to address some of the perennial problems that folks on this panel are going to talk about. How can we use tech to increase access to justice and increase efficiency? And from some of the research that Dan and I and Ethan and I see Michael on the call, Michael Wolf have done, we found that technology can also increase the opportunity for more creativity. So ethical guidance can help foster the best and help reduce the risks. Otherwise, without it, we can face the magnification of imbalances of power and risks. And I'm not going to say very much now about AI bias. I'm sure other people will also speak to that, or we can come back to that. But I want to say that there is an atrocious record, particularly regarding AI bias and race, but also around class and other identifying factors. And why would we assume that just because we're using software inside of a process where there's supposedly a neutral party involved, that all of a sudden software will have no AI bias? So this leads me to the next point, which is that we argue that there's a need for an ethics update to both our own practices and also our systems. And that includes new requirements for software design. And I think that there's argument to be made that when a court reaches out and says we would like to utilize an ODR platform, that they can set standards regarding AI bias, transparency, just like they would set standards around data security as an example. So as we do updates, this will clearly influence our training curriculum, and as I mentioned already, the kind of protocols that we have for our own practice. And I think it's useful to incorporate in the conversation thinking about self-regulation, where we have an opportunity to think about how we can improve our own practice, especially in collaboration and conversation with others, but also our membership organizations and arguably government entities can play a role in this and already are beginning to do so. So speaking of self-regulation, I want to point out that in the article, there are several activities regarding applying ethical principles to the development of standards, or also to this idea of thinking about how we could improve the ethical use of technology in our practices. So I pulled up here an example of a set of standards. They come from the International Council for Online Dispute Resolution, and you can see they may look fairly familiar and resonate with the core tenets of most ADR and court practices, of course. But when we think not just about the theory of how we engage or what the practitioner does, but we also think about the algorithm, whether machine learning is involved. When we think about product design or software design or system design, and by system, it could be the software system of an ODR platform, but it could also be how technology fits into a larger system of handling disputes. How the focus on accessibility may look different across each of these sectors. And so this is hopefully something that will be stimulating for people who are thinking about their own practice or system design, or if they're interested in doing activities for students. So I look forward to hearing your questions and your comments and your ideas, and I'll turn it over to my co-author, Dan.
Thank you, Leah, very much. When we started working on this chapter, we started with the assumption that not just about, every ethical imperative, every ethical guideline that we operate with as third parties is affected in some way by the use of technology. The one that gets talked about most, and I talk about it myself when I talk to practitioners, is confidentiality, data security, and privacy. I mean, that's the one that is easiest to understand, perhaps, in terms of the impact of technology. What I'd like to do in my segment here is turn attention to another one of the ethical standards, and that is competence, which I think is affected almost as much as confidentiality and privacy. We tend to think about self-determination as being a thing that happens at the back end of a mediation process, where the parties choose or choose not to accept a resolution. In my mind, self-determination starts at the beginning of the process, when parties agree to come with us into a process that we have explained to them and which we're offering to them. So competence in the sense of your competence as a third party is important, and competence in the sense of their competence as parties entering into the process. We heard yesterday from mediate.com a report out about some training standards And I think those are extremely important as an ethical consideration in the field, because we have these 40-hour courses in mediation that essentially, when you get through, they say, bless you, and you're now a mediator. Almost none of those, not to my knowledge anyway, include a meaningful discussion of technology as part of that basic 40-hour course. It's starting to happen, but we're not quite there still. And so the idea of being able to actually talk about the impact in our training, I think is one way to prepare us and to make us competent. But looking at the other side of the coin, if I invite you into my conference room to do a mediation, I don't have to explain to you what a conference room is. I don't have to tell you how to get there other than giving you basic directions. And I don't have to teach you how to talk when you're in that room. I may have to teach you how to talk respectfully. I may have to teach you how to talk to get a good outcome, but I don't have to teach you how to talk. But if I'm using technology, if I'm creating a virtual space, then I'm inviting you into a place that's strange to you. And so I do have to teach you how to get in. And I do have to teach you how to talk once you're there, especially teach you how to talk in an effective way. So I think in terms of ethics, what this means for third parties is that the way we prepare ourselves and the way we prepare our parties to enter into that virtual space that we've created is at base an ethical issue. If I am doing it well, then I'm inviting them into a space where they can have a feeling of safety, a feeling of order, and a feeling of self-respect. If I'm doing it poorly, I may very well be creating an uneven playing field without intending to do so. And so I would just say that as we think about ethics, it's easy to think about confidentiality and some of the others, but I think we should be paying a lot of attention to the notion of competence and what it means for us and for the parties that we're bringing into the spaces that we create.
Thank you, Dan. Thank you very much. Anything else you want to share before we move to the next chapter?
No, I think we've burned our time.
Okay, thank you very much. So I now turn it over to our colleague, David Larson. Thank you.
Thanks, Leah. So I'm going to be talking about accessibility for persons with disabilities. I believe we need to do better. What technology are we going to use for our systems? What are going to be our standards or ethical principles? Leah and Dan have raised some great questions. Some of those are going to be difficult to answer. I think it's a really exciting time, a really important time. Leah referred to the ODR Standards, the International Council for Online Dispute Resolution. There they are again. I'm co-chair of the ABA ODR Standards Task Force. We're working with our drafting partners, the National Center for Technology and Dispute Resolution and the International Council for Online Dispute Resolution. We're still not sure whether we're going to come up with standards or guidance, but we're building on these standards that were articulated and promulgated by the ICODR group. I think they're outstanding. When we met as an ABA Standards Task Force, I encouraged us to look at these as a starting place, and we have. And now we are embracing the opportunity to work with NCTDR and ICODR to expand on those standards. Accessibility, of course, is important for everyone, and that's my topic today. So as kind of a thematic approach, I just want to encourage people to avoid conceptually segregating persons with disabilities. Accessibility is a universal issue. You could be in a crowded room with a lot of noise. You'll really appreciate captions. There's lots of instances where accessibility is not simply tied to access for persons with disabilities. I'm going to talk a little bit about courts and legislation, what's happening in terms of liability with the ADA, make reference to the Ontarians with Disabilities Act, which was a leading piece of legislation in the field, then this misguided Online Accessibility Act that was introduced in the United States Congress. And I'm going to talk a little bit about best practices when it comes to making digital conduct accessible. So we've talked about this. ODR can improve access to justice. As we know, people sometimes struggle to make court dates because of shame, fear, no vacation time, transportation issues, childcare challenges, maybe physically intimidated, maybe disability, mobility issues. So I firmly believe, and I think most other people here do believe, ODR can improve access to justice, but not always. We have to be a little careful. Now, I've talked about this before. I think as we move into this virtual world, mediators have a dirty little secret that when you're neutral, there's lots of things you can do to really influence the process in terms of timing and reframing. I think that when we're going online, that ability to influence the process actually grows exponentially. And kind of Dan made the reference that when you start out, people might need to be introduced to the technology. For me, one of the concerns is that as you're introducing the parties to the technology, you become the answer person, and you're telling them where to start, what to click, what to do, and you spend some time doing that. And then in a moment's notice, you turn around and say, but I'm just a facilitator. Don't look to me for answers. I'm just going to help you move together to hopefully reach some kind of a resolution. And I'm not sure that cognitively we can make that transition as easily as it's sometimes assumed. And once you've established yourself as the answer person, I think it might be difficult for parties to think of you in any other way. So when it comes to introducing people to the platform of technology, which I think is essential, I believe it's a really good idea to do it with two different people, to have somebody come in and be that person, the answer person for the technology and the platform, and then to have the neutral work with the parties as part of the resolution process. You can do all kinds of things if you want. With technology, you can alter form and voice and timbre, control timing, alter information. The opportunity to play with the process is pretty great. And I think we have to be really careful about that. Now, we're never going to go back. Some services may never be offered again face-to-face. I think it's a very real danger that vulnerable populations, including persons with disabilities, are being excluded from our new normal digital world. And that's one of my concerns. And I think the concern of a lot of people that are working on this, and people are working with us on the new standards. There's a lot of pressure to go online. We're rushing online. We need to ensure that the processes are designed so that they're going to be accessible for persons with disabilities. We need to ensure that technology is actually improving access to justice. And I think one misconception is that I'll go back and fix it later. I'll make it accessible later, but then people either never go back, or when they consider going back, they say, boy, that's going to take a lot of time. It's going to cost money, and I don't want to do it. And maybe not quite as blatant as that, but it doesn't happen. One thing I wanted to mention is, so I'm a professor at Mitchell-Hamlin School of Law here in St. Paul. I'm chair of the ABA section of dispute resolution. I'm also the system designer for the New York State Unified Court Systems pilot program for small claims. And we're trying to be accessible. And one thing we're doing is, in the beginning of the process, we have soft opt-out questions. And things like, are you comfortable saying what you think and standing up for yourself? Do you have difficulties accessing the internet via computer or smartphone? Do you have challenges with reading or seeing text on a computer or smartphone? Do you have difficulty reading or writing in English? Is there any other reason why it might be difficult for you to use ODR? Now, the reason I put it up here is because these kinds of questions do go to disability accessibility, but what we've tried to do is not to be too paternal about it and make the decision and say that, well, if you got a disability, you have some difficulty accessing the internet, some difficulty reading or seeing text, then you can't use the platform. What we are doing after each of these questions and asking people, do you still want to continue with online dispute resolution? Because the fact may be, yeah, I have some challenges, but I've learned how to manage those challenges. Or I have a partner I work with, and we work together, and I can easily overcome whatever challenges I have. So on the one hand, we're trying to be attentive and responsive to the challenges that people have, but also we want to preserve this idea of party autonomy and let them make decisions themselves. We ask yes or no after each of these questions. The other party can't see the answers. Who should be concerned about? Well, we could do a long discussion about persons with disabilities. Some reports say 1 in 4 Americans have disabilities. I think it's true that most people will have or know somebody with a disability. As we think about accessibility for everyone, I'm not sure we should limit our concerns to legal definitions of persons with disabilities. If you look at the websites and a number of institutions and entities have, there are all kinds of accessibility problems. Here's a couple studies that 41% aren't accessible of government websites. There's a digital divide for persons who have visual impairments. One study said that there were 70% are inaccessible for persons with disabilities of government websites. So when you look closely, the numbers are pretty disturbing. Is there more than one reason to create disability accessible material? Well, it's just good business. You're going to have larger audience, more customers. You're going to improve the lives of persons with disabilities, and you're going to avoid some lawsuits and some bad press. So it's good business. You bring persons with disabilities into the audience, into your customer base. If you have captions, and again, if you're in a noisy or difficult environment, you're going to help anybody in that environment. We've got many people, millions of people with limited bandwidth. So if you have a well-designed, uncluttered website that will be easy for a screen reader and easy for someone with a visual impairment to read, it's going to help a lot of other people who don't have the bandwidth to be able to unload, to able to download a very cluttered website. It's a human right. The United Nations Convention on the Rights of Persons with Disabilities are very clear about that. Persons with disabilities may not only be excluded from effective participation in dispute resolution, but again, my concern is their whole life in our new normal world. I don't know about all of you, but I really am living online now, ordering pretty much everything I need online. And it's really critical that I can do that efficiently and effectively. And if I couldn't, I'd be really struggling because I'm concerned about COVID still. It's still raging around our country. That's going to go away eventually, I pray, but it hasn't gone away yet. Article 9 says, promote access for persons with disabilities to new information, communications, technologies, and systems, including the internet. Article 13 says we need to ensure access to justice for persons with disabilities. So it's it's not just a moral thing to do. It's part of this international convention. And I think you might have liability concerns. ADA Title III, which requires public accommodations to be accessible, is a real concern. That has a definition for persons with disabilities. Physical or mental impairment substantially limits one or more major life activities. So if you've got that, if you have a record of that, or if you don't have that, but you're being regarded as having a physical or mental impairment that substantially limits one or more major life activities, then you will be within the Americans with Disabilities Act. Title III has great guidance for physical structures, but unfortunately not for online activity. ADA was written before we moved our lives online. We know that Title III requires reasonable modifications to public accommodations unless it would fundamentally alter the nature of the business. But now the question is, what does that mean in a virtual world? What's required? And is a website even a public accommodation? Does it fall under Title III? 11 years ago, Department of Justice says, okay, we're going to do something about this. We're going to engage in rulemaking. There are these web content accessibility guidelines that are really the gold standard for accessibility. They're quite detailed. The Department of Justice was talking about making those the applicable rules for the United States. The process stalled 6 years ago. They said, this is not moving forward as we would like. Maybe we'll look at Title II and Title III differently. Title III deals with government. Title II deals with government. Title III with private entities. Finally, the Department of Justice just withdrew notice for Title III. They decided they weren't going to do it. So we have no Department of Justice rules for Title III, no guidance. Websites can be, and I believe all should be, covered by the Americans with Disabilities Act. It's pretty well settled through court cases that if an entity has a website, a physical location, their website if you have a physical location, your website will be considered a public accommodation. But the courts of appeals right now are still divided, whether a website that is not affiliated with a physical location is going to be covered with the Americans with Disabilities Act. So I think is the wrong position to suggest that they aren't. In January 2019, we had challenges brought saying that, well, you know, if Department of Justice thinks this is so complicated that they can't promulgate rules, then I guess it's unconstitutional to apply it to anybody. If it's that confusing and that vague, then nobody should be subject to the Americans with Disabilities Act. But the Ninth Circuit said that, no, that's not really true. ADA was meant to be flexible. So the fact that the ADA has not issued specific guidelines doesn't mean that the statute can't be applied. And we think that all you need to know is that the ADA is flexible in terms of how it's going to be applied to different entities. So that's a little bit of a help that the ADA does apply to websites, at least for sure everywhere if you have a physical location, and some places even if you don't. But to say that the ADA is flexible isn't helping a lot. And what that has done is create a lot of confusion and litigation. When I was at EOC, I had an assignment to work on the ADA Title I for employment. We issued lots of guidance material, regulations, interpretive guidance, technical assistance manual. We don't have that for websites and for virtual activities. There's the link for, if you ever are interested in look what we do have for Title III, that's www.ada.gov. You can bring private lawsuits under the ADA for injunctions, no monetary damages, but you can get attorney's fees. And that's important because people are bringing lawsuits now, understanding that your only liability may be attorney's fees. What's happened is people are saying that, oh, I better cave and pay it because the faster I pay it, the lower the attorney's fees of the plaintiff will be. So I got to get out of this really quickly. So people are paying those lawsuits because they don't want the attorney's fees to run up. The problem is if you pay off one person, that doesn't prevent anybody else from suing because you may be then subject to a series of lawsuits. You can file with the U.S. Attorney General who can get money damages, but again, there's going to be a delay and there's only so many cases they can file. State law is possible. California, New York, and California in particular has this UNRU Act that says that if you violate the state equivalent of the ADA, each offense has a maximum of 3 times their actual damages, up to only $4,000 plus attorney's fees. DOJ used to bring cases and get settlements up until about 2015. They were forcing parties to actually conform to the Web Content Accessibility Guidelines. But when they abandoned rulemaking, then we had to go back to litigation with courts trying to set the rules. Again, a lot of confusion. You could see on this slide when DOJ was still involved up until about 2016, they were getting settlements. When they got out, those settlements basically disappeared because DOJ wasn't pursuing them, and litigation started to really increase. Here's a more recent slide. Put that first one on. It's a little easier to read. The point of this one is that you can see the litigation is climbing very quickly. These are just not ADA sites, but just digital accessibility sites. We're going to be over 4,000 this year. And keeping in mind that this doesn't count any of the settlement demand letters. This is just the actual litigation. So key question about jurisdiction is where's the plaintiff? Most of the cases are being brought because of the state law damages possibilities. They're being brought in California and New York. Typical week. Now, as we sit here today, you're getting 70 to 90 lawsuits filed each week. 20% in the state, about 80% in federal courts. A small group of plaintiffs firms are filing almost all the lawsuits with the same plaintiffs. California and New York are dominating the places where cases are filed. Certain defendants are getting the cases repeatedly, colleges, medical companies, automotive companies. plaintiff is blind or deaf is the typical plaintiff. That plaintiff is making multiple claims, often screen reader issues. They're listing WCAG issues, standards that are not being complied with. And if you do have an accessibility policy, they're looking at that closely and challenging it if you're not following it. Widgets are creating issues, and we're starting to get class actions. United States, we had this Online Disability Act introduced about a year ago to amend the ADA to add a new Title IV. It was suggesting that we should use the Web Content Accessibility Guidelines, but only the first iteration, 2.0, which was puzzling. Why not move to, we already had standards 2.1 and 2.2 were in progress. So it didn't make sense to just have it at 2.0. You couldn't file with the Attorney General until 90 days after written notice. That isn't a requirement for all plaintiffs and all damage claims. So I think we're getting into some access to the court's equal protection issues. The Attorney General could sue for equitable relief, monetary damages, civil penalties, but the court had to consider any good faith effort to comply, which again, I'm not sure I completely understand because the legislation of the ADA has been out there for 30 years now. I'm not so sure that defendants always get the benefit and privilege of having their liability protected by their good faith efforts. After you've exhausted the administrative requirements, you can have a private right of action. But if you bring a private right of action, you have to plead with particularity each element of a plaintiff's claim, which again to me seems we've got an equal protection argument again, because in most civil litigation, you've got this Ashcroft-Iqbal requirement of when you bring a case, what you have to do is plausibly suggest an entitlement to relief as opposed to pleading with particularity each element of plaintiff's claims. So they've raised the bar, or they tried to raise the bar for plaintiffs bringing these kinds of challenges. And again, I think that in itself can be challenged. So not enacted, but it's still floating out there. It's people are still considering. I think it was a terrible piece of legislation. I think the whole point was just to protect defendants and not really increase accessibility. In contrast, the Ontarians with Disabilities Act, they were in this field in 2012. They've just been much more responsive and protective for persons with disabilities. So I refer you to look to their legislation if you're looking for a model piece of legislation, not what happened in the United States Congress. European Accessibility Act is out there. My only concern about that is that compliance date looks a little too far out. I don't know why they're not mandating compliance earlier than they are. But on the other hand, I'm happy that they're being attentive to it and taking concrete action to improve and ensure access for persons with disabilities. Some best practices: adopt a disability standard. Web content accessibility guidelines, again, I think are the gold standard. They're easy to find. They aren't necessarily easy to read. They're going to take some time to read, but I think they still are a great guide. Comply with ODR principles and standards, and going back to the ICODR material, I think is really helpful. It does apply in the ODR context directly. I think anyone should have a disability accessibility coordinator to oversee what's happening with your website as you constantly do your updates, or you're making sure that those are accessible. You should include accessibility on your technology contracts and your request for proposals. So right from the outset, you're alerting people that you want that kind of protection. Test your website, use persons with disabilities. There's a good website. Color contrast is really a challenge for persons with visual impairments. This WebAIM contrast checker is a good way to check that on your own. Train your staff, maintain that training. There's lots of website accessibility organizations out there. There's some of them that can help you. They're not all the same. Some do automated checking, some use testers. I would recommend that you work with somebody that uses actual human testers on your website. Make accessibility a part of your job descriptions and evaluations, and evaluate all stages of your ODR system. Last thing I want to mention is that those of you who are involved with the ABA, and work in the field may be familiar with the Ray Corollary Initiative. It's a group that's dedicated to trying to increase the diversity, equity, and inclusion in the selection of arbitrators, mediators, and other ADR neutrals. The Ray Corollary Initiative, the RCI, has now been incorporated in Maryland. I'm a member of the board of directors. We're just starting out in our process. We think that this is going to have a lot of success. We know from the empirical studies that have been done to date that if we can have about 30% underrepresented groups on a slate to possible neutrals, that those appointment rates will go up. There is a direct correlation there.
So Dave, I think we're going to have to.
Yep, that's right. Yep, my last slide. So we want to promote further social science, empirical research to confirm that relationship. Here's our goal of at least 30% diverse neutrals, and we're trying to drive accountability and transparency to make sure people actually track what's happening. There's my book chapter. There's the book that we're talking about. If you have any questions, please contact me.
Thank you so much, Dave. We're going to turn it over now to Professor Alma Jadallah, and I just want to say I'm very excited to hear about your chapter along with Dan Rainey, so please go ahead.
Thank you, and our previous speakers, thank you for the rich presentations. They definitely have informed us on how we should think and complement our work in big and small ways. I'm very pleased that I had the chance to work with Dan. I think the evolution of this chapter is probably similar to the one experience he had with Leah. Multiple conversations, one-on-one, working with other colleagues, reflecting on our own practice, and observing other practitioners do their work. We focused on the cultural component, and I think that was a result actually of a development in the field. I would like to take the bold step and say that in the early 80s and 90s, when I joined as a student at the then Institute for Conflict Analysis and Resolution, many of the dominant paradigms has been focused on rational thinking of the parties, rational thinking of the mediator, setting up these one-on-one conversations and consistently looking at positions and interests. And I was very pleased after so many years to see in an old classic book by Sandoli and Vandermeer, who started showing the cultural paradigm and its influence in basic human needs and its influence on how we can actually better comprehend and understand the parties and the role of third parties in a facilitated mediation process. And by this, I mean really looking at the values and beliefs and looking at the worldview of everyone. And the basic needs, the non-tangible in particular, which is making sure we respect and show appreciation and acknowledgement for people while participating. But all of these have a lot of nuances, and Dan and I often got into these conversations about how do we write and what definition of culture do we adopt. And we really decided to take the simplest of the simplest, which is culture is the way we do things around here. And that's really a very complex statement in spite of the number of words it contains, because really the way we do things is by whose measure and who's looking at them, and how people are understanding it can vary from one individual to the other. So on top of this, given the pandemic, of course, there was an increase in online use the use of online mediation and tools. You could see how this component of culture has been tested and had to be revisited using online tools. So Dan and I went into really several conversations in the chapter, and he's masterful, I think, at telling the stories and really building the story along with mine around how did it show up. And I had a recent, actually, mediation case that I was doing for a multilateral organization between a private sector and a community. And we really hit an impasse and we couldn't go anywhere, because by definition, community meant something for the mediator, meant something for the organization and the investor, and meant something else for the community itself, because it wasn't a homogeneous group by any measure. They came together to put together a complaint, but internally, or the intergroup dynamics impacted that. And so it's a very small example about terms and terminology and references and where we come from, what we think we represent, identity politics all play in, and how do we capture that online is really a very big question. And so our conversation and our writing took us to really consider how many cultures are operating in this online platform. And I'm not going to say much, but we agreed, because I'll defer to them in a few minutes, we agreed that there are multiple of these that are operating during this time frame. Of course, the culture of the mediator, the culture of the parties, and then we'll talk about the fourth culture. So I won't give it away yet. But to me, what was important too in our discussion and chapter, which we really wanted to share with you all and communicate, is that one of the biggest challenges is really understanding how people think, their cognition, their affect, how they feel, and how both of these impact their behavior. And how do we capture that online? So it is a challenge, but it doesn't mean that online platforms don't give us opportunities. The synchronous and the asynchronous possibilities of utility of that platform are quite important. Also, the idea that communication could be enhanced and communication could be looked at if we understand how the role of filters and how we understand how people are communicating. And also as practitioners, if we acknowledge that these tools have been designed with a particular frame of reference, a particular worldview, and reflect really the design, the people who designed it. And we really pay attention to that. And I think more importantly, culture shows up in the way we frame the issues, the way we label the parties, we worked with them. I shared recently an example with them that simply by using the two words, chairman and engineer, with a party that was very hard to work with because he felt disrespected and his credentials were not acknowledged, made a huge difference. My cultural competency and fluency in that particular region allowed me to pick the nuance of discontent by using first names. Maybe a very nuanced interaction, but given the debriefing we had, a lot of people said, wow, he really shifted 360 degrees, and it's just acknowledging the other person. But we also then, and I agreed, that developing the cultural competency and fluency and with the online platform takes a long time, and we have to be humble about how we get there and continuously look for online insiders to share with us. So I'm going to turn it to Dan now. I'm sure I've missed some key points, but I'm sure he'll fill in. Dan, over to you.
Thank you, Alma. And I'll say also, it was a pleasure working with both you and Leah. What can I say? You don't get better colleagues than that. Well, I'll do this very quickly and try to leave a little time for Ben. He's been sitting there very patiently waiting for us to get through all this stuff. Basically, I think the point that we started with is that even though international, cross-border, and obvious cross-cultural interactions are abetted by, made easier by, and are becoming more common through the use of online technology, that forgetting all of that for a moment, that even if you're operating in the same nation, in the same community, it's impossible to have a totally non-intercultural relationship because of the worldviews of the people who come into the work that you're doing. And so we tried to focus on three sets of cultural frames, three sets of worldviews. The culture of the parties, which we talk about a lot. When we talk about intercultural communication and mediation, the conversation most easily goes to what are these people like that we're trying to work with? How do we adapt? How are they different, etc.? And that's important, obviously. But there's also the culture of the mediators themselves. Where are you coming from? What does your worldview tell you? How do you operate? How do you see reality? And that is something you have to adjust as you move along. The one that I think gets the least talk about, although it's getting more and more these days, is the culture of mediation, not the culture of the mediator, the culture of mediation. What are the assumptions you bring with you into the interaction based on your training and your experience and the culture that you come from as a third party? There's an interesting book, Press and Deason's book on, not a book, sorry, an article on embedded assumptions of whiteness in mediation. It's in the Cardozo Journal of Conflict Resolution. And whether you agree with all of their points or not is irrelevant. What they're talking about is that just like you can't have a neutral piece of technology because the person who programmed it programs in some of their assumptions, you can't have a neutral mediation process because the mediator is going to bring with him or her some assumptions about how things ought to be done. The problem with all that is, in a context of culture, is that my assumptions about what's right in my worldview as a third party, because of my training, my worldview and my assumptions because of who I am as a person, and the assumptions that you make as in your worldview as individual parties may be totally incongruent. And so we have to make an extra effort, in my opinion, and this goes back to some of the ethical things we were talking about before. Because to me, I've always been sort of driven by, to some degree, human needs theory. And so the question that I ask, and I think it's very much a culturally based question, is what do I need to do as a third party to make the parties feel secure and safe in this environment I've created? What do I have to do to make them feel that there's a structure they can understand and count on, that there's some predictability about what's going to happen? And very importantly, how do I make them feel like they are valued? How do I deal with their sense of self-worth as a third party? And Alma's example about the using the title of engineer, professor engineer, I think it was, is an excellent example of that. Here's a person who shut down and wasn't cooperative because he wasn't feeling respected in the process. And just by using the terminology that was appropriate, you're acknowledging him, and his self-respect is to some degree fulfilled, and he begins to behave differently. And to me, that is the bottom line on dealing with intercultural communication, intercultural mediation. What you're trying to do is get people to a point where they're interacting in a way that is positive and works for them, as well as being conforming to your own assumptions about what mediation ought to look like as a third party. And so if you read the chapter that we wrote, we say all of that with a lot more words and a lot more examples. But to me, it's a sense of how do I engage with my parties, probably before we begin talking about their issue, in a way that makes them feel that they are entering an environment where they're going to be safe, where they can predict what's going to happen, where they're going to be respected. And if I can do that, then what I'm doing basically is adapting to their worldviews and their cultural expectations of our process. And that, we think, is a very important way to begin a mediation.
Thank you, Dan and Alma. You're weaving together these approaches that think about equity, culture, and ethics. Thank you so much. We now turn it over to Professor Ben Davis. Really looking forward to hearing what you have to share.
Well, thank you, Leah, and thank you, everybody, for having covered everything that I could possibly say. So I will just be very brief. First of all, I just think in terms of at this point, because it's so early, I guess, in my thinking of this, is I only come up with words that are kind of vessels, okay, if I can say that. I don't know necessarily that I have content to the vessels that I'm going to be throwing out to you, but I sense something intuitively. So let me just throw these out to you. One is not a vessel of mine. It is actually a vessel of one of the Central Park 5 guys who was acquitted and then went on and did a PhD. When somebody was asking him about what did he think about technology when he came to speak at University of Toledo, he said, "Oh, you mean tricknology?" And I was like, wow, you know, the concept of technology, you know, that he just kind of threw out there, what is inside that concept, was just something that kind of teased me. And so I've kind of had this, I considered it a kind of word that helped me sort of come to a little mantra, which was like technology, yes, technology, no. And then the question becomes, what does that mean? And another way of thinking about it is to think of possibly of technological pathologies, if we could say it like that, or pathological technology, in terms of there's technology that has minor pathologies in the way that it operates under some definition of operating. And then there would be technology that would have major pathologies in the way that it operates, to the point that we start to get to this place called technology that the guy was talking about. And that's kind of like a sliding scale I think about. And again, these are all vessels. I don't have things to put in them right away, but these are the ways I try to think about these. One of the important pieces of a thought, at least that's been struck me with regards to what is going on, was there's a book that's come out by a professor of emeritus from Harvard Business School, which is called The Rise of the Surveillance Capitalism. And the idea since 2001 or so, essentially, there's been free reign to the persons who develop technologies under a self-regulation model as opposed to a governmental oversight model. And we've seen sort of where we're at, where each of us becomes kind of a product in terms of what our behaviors that are being looked at. And I found that really interesting as a thought, because to the extent that we are being sort of modified in the way we are by the way technology is being used on us, or put it another way, it's me against the Cray computer, and the Cray computer is winning. I just think about what are those implications. One of them being that you hear a lot of people talk about artificial intelligence right now and the various aspects of that, and you hear a lot of talk about algorithms and what those are, and the way that they operate without any moral compass. At the same time, I've always thought that we should also think in terms of, well, can algorithms do algo wrongs? Meaning there are the results of whatever they're doing. Can they end up doing that something that operates negatively? I think some of that I'm starting to see is coming out in what they're calling it the Facebook papers now, or maybe the Meta papers, and now I guess in the terms of human interventions, in terms of weighting different types of responses that can have the effect of increasing the amount of discord, as opposed that because we feed people more stuff that's consistent with their anger, as opposed to feeding stuff that's more consistent with peacefulness, things like that. But that's another vessel that I meditate about, is algo wrongs. At the end of the day, technology and dispute resolution, I think, and I would just submit and try to put this in the paper, the technology that we have, or the technologies that are used, I hope, can serve a way to meet the needs of what I would call the lowest common denominator person, the person who is not technologically sophisticated. For example, just to take 3 different settings, your computer versus an iPad, which I'm on right now, versus a cell phone, which is a iPhone 13, I guess. Here, my son got me the newest one, versus something that's farther down the scale of iPhones to an iPhone 5, I don't know, or whatever you've got in the other kinds of technologies. How I access things under each of those, I see the difference between them. And so if something is set up for people, expecting people to have computers, it's already doing a whole series of exclusions all the way down the line to the more rudimentary types of technology that people would have available. And so it's those kind of things that I think about in terms of lowest common denominator, I guess, or lowest functioning technology vision of how the design is done so that someone isn't inadvertently or advertently excluded. Another issue, of course, and maybe I'll end with this, is that what are the incentives of the technology developers with regards to what are the technology is there? For example, there was always going to be a tendency to either, whether it's through seeking venture capital or whatever, to try to meet a certain market and do something that market speaks to. Now, if that market is broad, that's one thing. If it's narrow, that's another thing. These are all kinds of decisions that are made in terms of how the technology is designed and what it's supposed to do. And also what that market wants the technology to do, which is a whole nother kind of part of this that bothers me. I got two stories to just give for that. One is there was a technology that apparently allows you to break inside these and listen to what everything that's in there, and it started to be sold to countries that are using it to break into the phones of their dissidents and essentially control dissent. Well, there's a technology that's kind of having a perverse effect. And then the other one, of course, is the one that many people know about, is this scandal in England with the Horizon scandal, where all these postmasters and assistant postmasters were prosecuted and went to jail for allegedly stealing money out of the till because the computer said they had, because they had a software system that verified things. And it turned out there was a glitch in the software system that was, however, this went over 20 years. There was a one woman who actually had a baby in prison. Okay, I'm giving you the idea of just sort of, to me, a clear algo wrong of a high level. But there are other situations, and there's a town in Florida where there's an effort to sort of stop people from committing crimes that are suspected, almost like in a pre-crime vision of some kind of minority report movement. And it's basically that you're having ordinary people who have not committed any crimes being harassed by the police based on what the computer says their risk is, their probability of risk is. And it may hide actually just an effort to try to kick people out of that community. What the computer is saying, so somehow it's neutral in some kind of thing. Again, what does this have to do with ODR? I think that all these things just suggest ways to try to think about where we're doing algo wrongs and where we are creating pathologies, whether minor or major ones, and where we risk being more towards technology than the kind of technology that I think everyone here aspires to have. So I'll stop there.
Thank you, Ben. Thank you very much. So interesting. Thanks for introducing and furthering terminology that you've heard from others as well, like technology. I wondered if I could begin our question and answer time by asking a question to you, and I'll plant a question for Alma and Dan to speak to, and then maybe we can turn to the audience and just welcome people to put questions in the chat or to freely raise your hand after these questions get addressed. So Ben, what does access to justice mean to you in the face of technology, the reality of, as you put it, algo wrongs, and also the reality of, this is brand new, I've never heard this, but the technological pathologies. What does access to justice mean if we're going to be engaging in ODR when this exists?
Well, first of all, you've made me really happy, Leah, by saying that technological pathologies you hadn't heard before, because that came up to me last night. Okay, so I wanted to Google to see if anybody had already said this. Okay, so I'm like, great. And the analogy I was coming from was pathological arbitration clauses, which I used to write about 25 years ago. And there's a guy 20 years before me who talked about them. So I was kind of updating his thing. So, you know, I personally, this is just me. I know that we've got sort of democratic and authoritarian visions of the world that are out here all over the world in some place and time. So I don't have a clear answer, but I do think that underneath access to justice is something that kind of respects human dignity. Okay, I think that's the heart of it. And so then the question is, what is a kind of technology, what kind is an ODR system that respects human dignity? And this can be complicated because actually you can have corporations involved in this who are not human, right? So, but bear that in mind. I always I think about how we can provide a way for somebody to access whatever the method is in a way that they have confidence that it's a neutral process. They don't have that second guess in their head about what they're getting into. And I'm trying to give an analogy of that, but U.S. District Court is down here, right? And there's a sense that there's a court with certain processes, and I'm not going to be played with too much. Now, there are other people who would say the law is this way, and there are all kinds of biases that are in the system, all right? But I guess I sort of expect if I go down to the courthouse that they're going to act within certain limits, I guess is what I'm trying to say. I even would say the analogy I would make would be when you go to the DMV to get a license or something like that, you know, there's a way that you're treated by the person at the DMV that is respectful of your human dignity. And Lord knows it is possible you may have had experiences where people treat you like you're the last idiot ever present, right? And you feel kind of shame or hurt, you know. And so to me, it's like, try to find ways. I love the questions that Dave presented on the front end of the small claims, to try to speak honestly to the person about what they're going to be going through, to help them help them transition to the step of the technology. And then the technologies that they're in this ODR space is one that really operates in some kind of a neutral fashion. You know, there are back-end things like who gets appointed the mediator, who gets appointed the arbitrator, those kinds of things that can be concerns. I remember when the Uniform Domain Name Dispute Resolution System was put in place by ICANN as a dispute resolution mechanism, there was some research done that basically defendant-friendly neutrals tended to get reappointed in other cases, while defendant unfriendly neutrals tended not to, independent of the qualities of the person. They tended to, you know, the system would sort of select for the ones who would get inordinate numbers of cases as opposed to sort of a random method. And that raised some issues about the whole selection process that was there. I also just would maybe finish with this, to think that it's, you know, being reflective of the society, whatever that means, that is operating. In other words, that people see themselves in the system, so that that helps to give it credibility. It doesn't look alien to them, in the sense that everyone involved is not somebody that looks like them. Having been in international arbitration at a point in time when essentially there was never a thought that a woman could be in the role I was in, you know, 8 years later, there were women in that role. And guess what? International arbitration now has a president of the ICC court who was a woman. And so obviously that was just nonsense 30 or 40 years ago, in that thinking about, could a woman do this role? You know, I think it's important that people see people that are like them in what they're doing, to help build their confidence in what's going on. I'll stop there, maybe.
Thank you, Ben. So Alma and Dan, I put a note in the chat, and then again, I welcome the audience to put in questions or comments that you want us to raise before we close over the next 5-10 minutes. So I turn it to Dan and Alma.
Okay, I'll answer very quickly and then let Alma have the last word before she has to bug out at 11:15. The challenge that I see in considering culture at the levels that we talked about is that there is such a high level of uncertainty that you have to take some actions to lower the uncertainty. There's something that my wife and I, Julia, who's a better mediator than I am, something we call the Colgate Crest caveat. And basically it's, if you give me 300 million people and a little bit of data, I can tell you within a percentage point what toothpaste they'll buy next year. You give me one person out of that 300 million, all bets are off. I have no freaking idea, right? Because the only way I can find out what that one person thinks and what their worldview is by asking them questions about what they think and what they value. So for me, what this means operationally for a third party is that I better not make any assumptions about what the cultural worldview of the person I'm dealing with is, because I'm not going to be able to tell accurately by what I see and what I hear unless I ask questions that allow me to probe that a little bit. And I have to ask those questions respectfully, and I have to listen to what they say, and then I have to be able to adapt to what they say as best I can. So that's the way I would answer that. It puts the onus on me as the third party to ask questions about, respectful questions about what the worldview of the individuals I'm working with are, and to see whether I can adapt my approach to our work respectfully into those assumptions and those worldviews. Alma?
Yeah, I have little to add, but I think one of the biggest challenges is how to stop guessing and how to stop, how should I say it? I really have the word in my mind, but I'm trying to be careful of not to be pompous. One of the biggest challenges with people who have practiced for a long time, they think they could predict the behavior, which then I think touched on. And to really be careful about predicting, even if you're from the same culture of the parties, really their logic may not be uniform with yours. And with the online methods that we have, there is little room for you to kind of sit for long hours and keep asking and probing, because we are in an artificial setting after all. So one of the challenges is how do you get closer to their thinking with the limited time you have online, because we all get fatigued by that. So a quick answer for that. And thank you, Leah. Excellent question.
Thank you.
We have one, I think, in the...
So there's a question that I invite any of the panelists to speak to. Thank you, Narges Keshavarts. Thank you for the presentation. I have a question regarding the effect of cultural differences to the outcome of a dispute settlement mechanism, for example, an award. So please, anyone who'd like to speak to that, and then please note the comment that Dr. Simpson shared with us. Thank you very much.
Go for it, Ben.
So I think that inside that culture question, since we're talking awards, is also different aspects of culture. For example, let's talk about legal culture. Civil law trained person versus a common law trained person. That can have a huge influence on the manner in which the people see the same issue as to the award that would come out, imagining a 3-person arbitral tribunal in that setting. I do remember an Italian arbitrator who once said that when he was named in a case and saw that the party was from this or that country, he would first look to find out what are the greatest literature of that country. And he would read that literature just to get a sense of sort of the culture of that, what is considered the greatest literature in that country. I don't know. In Ireland, I guess if it was an Irish party, it would be James Joyce or something that you would just pick up something to read there. If it was in France, the party was, I guess, Molière. You can pick your country in the world and try to imagine what would be that. That's how he approached before he went into the arbitration, to try to help him access the cultural dimension of what he or she would be hearing. And there's so many aspects of cases with regards to, for example, what is courtesy? What is it to be courteous in a different culture? And how that would impact on how that arbitral process happens. For example, if you go to visit a site in a given country, that the party from that country might take the view that you are his or her guest and that everything there should be paid for by them because you are a guest. That's how it's done. So the other side might find that really bizarre and thinking that that's going to cause bias, you know. So navigating that cultural dissonance by the tribunal could be a very delicate but important thing to do to make sure no one is insulted or hesitant about what happens. So yes, it can have a lot of influence, and the ability and the effort to try to do some kind of cultural gymnastics, if I could say it like that, with regards to what's going on is really something that certainly a chair or a sole arbitrator, that can be a wonderfully useful skill to be able to try in some way to meet the cultures where they are.
Thank you, Ben.
I wrote,
Leah, I'm willing to stay on for as long as we need. We're beginning to lose people. So I think there are other things going on, but I just want to make the point that we can stay as long as you want.
Yeah, I actually was going to propose that we officially close in just a moment. I wanted to make one comment about Dave's brilliant list of soft opt-out options, because to me, that's a wonderful example of when we incorporate technology and creative thinking, we actually also can take that to offline. I think that's a wonderful thing to do with folks, even if we're meeting entirely face-to-face, is to consider asking them whether they feel comfortable in that environment. That speaks back to the comments that were made by all the panelists around culture, around equity, around ethics. So I think that was a really helpful example, Dave. I wanted to thank you for that and the contribution to the New York courts for that. Before we do close, I want to thank all the panelists for enlightening us and remind you, I put the note in the chat about where you can get a discount on the book, and also remind you that there are other author panels and other exciting Cyberweek events today and then Wednesday through Friday. And there's a social gathering every day. Tonight it's 6 Eastern time and Thursday night 6 Eastern time. And we'd love to just be able to connect and hang out with folks. I'm certainly going to join as soon as I am done teaching my classes on Tuesday, Thursday. But let's give the panelists our thanks, and I wish you all the best of health. Thank you so much.